A very good morning to Dr. Hannah and all my dear friends. Today, we will be presenting MGM3352 activity number 2, I rest my case. Now, I shall be sharing the screen with my PowerPoint presentation. Here, the first slide we have mentioned the name of our team members and the name of our team, which is Justice League. This is activity number 2, I rest my case. Now, moving on to the second item, the second slide is agenda, where we have classified it into 6 main parts, starting with the case in discussion, which basically is the question, the facts of the case, the third one is issues of the case, the fourth one is the law of the issue, or which is also called as the relevant law. The fifth one is the application of the law, and the last one is the conclusion of the issue. Now, to start with case and discussion, I will not discuss much on this because this basically is the question itself. But in this question, I have highlighted a couple of things which needs our attention, which are an accidental fire, and it is neither Mr. Mamujan nor Mr. Frederick's fault. Now, moving on to the next one, this is the fact of the case. What are the facts of the case? Mr. Mamujan and Mr. Frederick enters into a contract for erection of machinery in Mr. Frederick's premises. The payment due after completion in 2 years, including repairs and maintenance. There is an accidental fire which occurred in the premise, and complete materials and machineries were destroyed without any salvage. Now, the crucial point in here is neither party is at default for fire. Part of the work was completed. Mr. Mamujan requests compensation for the work completed, but Mr. Frederick blatantly declines to pay. Mr. Mamujan decides to take things to the court to get the claim settled. This is where we come as lawyers. Now, before getting into the specifics of the case, why I have mentioned that neither party is at fault for fire here is because being Mamujan's lawyer, I just wanted to see whether we can add additional things to our ground, saying that maybe there was a negligence from the part of Mr. Frederick which led to the accident. But here, there is no negligence because the facts very clearly states that it is a fault of neither of the parties. So which means we can understand from that statement, this is an act of God or force majeure as we call it. Moving on, here we highlight the issues of the case. What are the issues that we are trying to address through this presentation? Okay, the first, this is all part of one issue, so that is why we have not classified it into different issues. This is all one issue that we are trying to address. The first part is whether doctrine of frustration can be invoked under the Contract Act of 1950. If yes, in case it's a yes, then should the contract be completed or will the contract become void? Then, in the light of that, Mr. Frederick, who is the defendant in this case, response of not agreeing to reimburse the expenses incurred by Mr. Mamujan, is it fair and just in the eyes of the court? Then, can Mr. Mamujan legally corner Mr. Frederick and make him pay for the damages borne by Mr. Mamujan? And by extension, in case the doctrine of frustration is applied, can the claimant is Mr. Mamujan, resort to the effect of frustration under various laws? Now, moving on to the law of the issue. This could be said as the most crucial part, apart from the conclusion, the most crucial part where the law comes into picture. Here, we discuss the relevant law that could be applied to this particular case that we have in our hand. Doctrine of frustration. Discharge by impossible under section 57 subsection 2 of Contract Act 1950. Here, since neither of the parties are at fault of the accident, this can be called as force majeure or act of God. So an example, a case law is also highlighted here, which goes by the name Tyler versus Caldwell of 1863. Here, the judgment said that since it was an act of God, the claim is rejected because the contract was frustrated because of fire. Contract is impossible to perform. This particular case is regarding a person hiring a music hall for 4 grand concerts and then claiming compensation because there was a fire and he was not able to perform. But the judgment said that the claim will not stand in the court. Now, effects of frustration. So this is basically divided into 2 parts. The relevant law is divided into 2 parts. One is doctrine of frustration and the second one is effect of this frustration. The effect of this frustration has 2 parts under it. It is again bifurcated. The first is the Civil Law Act of 1956 and specifically section 15 subsection 2. Here it says money due but not paid before frustration ceases to be payable. If the money has actually been paid, it must be restored. And here the part I have highlighted is the main crux for us as Mamujan's lawyers. If expenses occurred before the contract becomes frustrated, court has the discretion to order payment of the amount of the said expenses. Now, the second part under effects of frustration is Contract Act itself by section 66. When an agreement is discovered to be void or when a contract becomes void, etc., 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 the highlighted part says that to make compensation for it, to make compensation for it to the person whom he received it. So these are the main laws that can be said to be applied to the issues in hand. Moving on, application of law. Application of law is how the relevant laws that we have just discussed can be correctly applied to the case in our hand right now. So, since the fire accident rendered the impossibility of execution of contract, doctrine of frustration is applicable. So when we say that there is a fire, doctrine of frustration is applicable because the event becomes impossible, contract cannot be executed. When the doctrine of frustration is applicable, the contract becomes void. Once the contract is void, there should ideally be no responsibility fulfilled and no duties to be discharged. The reciprocal promise part of it is not in the existence anymore. Having said that, the significance of effects of frustration comes into picture. Since section 15 subsection 2 of Civil Law Act 1956 provides relief for the claimant to recover the amount of expense that occurred before the contract became void, Mr. Mamujan can seek the same. So Mr. Mamujan or us as his lawyer can invoke this section and apply this section for this particular case. Now, furthermore, to strengthen our ground, section 66 of Contract Act 1950 stipulates the defendant to make good the expenses incurred by the claimant by way of compensation. Now, based on the two aforementioned cases, the doctrine of frustration shall be invoked, but still, Mr. Mamujan can seek relief for claim in light of these relevant sections in the Act in discussion. Now, moving on to the conclusion of the issue. So this is where the answers to the questions asked would be given. This is where the judgment comes in the question. So since the relevant sections, subsections, Act and law is cited, the judge should ideally rule in favor of Mr. Mamujan. The court will pass judgment allowing Mr. Mamujan to claim the amount from Mr. Frederick. The court shall hold a doctrine of frustration is applicable under section 57 subsection 2 and hence the contract shall be voided. Since the contract is voided, both parties shall be excused from executing the contract because it became an impossible contract after the accident. However, section 15 subsection 2 of Civil Law, section 66 of Contract Act can also be applied in this relevant case. Since it is applicable, claimant's loss shall be settled by defendant. The court passed judgment in favor of claimant, that is Mr. Mamujan, in Mr. Mamujan versus Frederick 2020 case. Now, a couple of things I have not included in this slide, but I would still like to discuss are the law of issue points. There are two case studies that I have not case laws that I have not included it, but would still like to explain a little bit. One is Pacific Forest Industries SDN Berhad and Anor versus Lin Wen Chi and Anor 2009, a Malaysian case, which has defined or which has also ruled why doctrine of frustration can be applied. So that is one case that we can quote here. Then there is a global case. It happened in Hong Kong, so it won't be very relevant in Malaysia, but it is only to give a logic of how this doctrine works. It was Lee Chin Win versus Swan Yi Shuang in 2004. These two cases explain the effects of frustration, and both parties should be brought back to the situation on how they were before commencement of the contract. Now, since this conclusion is also discussed, I have to say that I rest my case here and that the court gave its verdict in favor of my client. So this is a success story. Thank you everyone for patiently listening. Thank you my teammates and our dear lecturer. The YouTube link will be updated while I will be giving the PowerPoint presentation to you. Thank you, ma'am.